Section 2, the Statute of Frauds, Why Real Estate Agreements Belong in Writing. The first "but he said" moment. Marcus and Elena are excited. Their offer on David's Queen Creek home has been accepted, and Daniel is beginning the process of moving the transaction toward inspections, financing, title work, and closing. At this point, everyone believes they understand the deal. Then Daniel's phone rings. Marcus has a question about the stainless steel refrigerator in the garage. During the showing, Marcus remembers pointing at it and telling David that it would be perfect for storing drinks. According to Marcus, David responded, "Don't worry, I'll leave it for you." David remembers the conversation differently. He says he only told Marcus that he would think about leaving it. Imagine you're Daniel. Marcus says, "David told us we could have it. We shook hands on it. What would you do?" This is one of those moments when an agent learns why experienced brokers constantly say, "If it matters, put it in writing." Why Arizona has a statute of frauds. Arizona's statute of frauds is found in ARS Section 44-101. Despite its unusual name, the statute does not mean that someone has committed fraud. It identifies certain types of agreements for which an action generally cannot be brought unless the agreement or some memorandum of it is in writing and signed by the party to be charged. One of those categories is an agreement for the sale of real property or an interest in real property. Think about why that rule makes sense. David's home is selling for more than $500,000. Marcus and Elena are taking on substantial financial obligations. The transaction involves financing, title, inspections, disclosures, possession, closing dates, property condition, and numerous other terms. If a disagreement occurs 6 months later, a judge should not have to reconstruct the entire transaction from statements such as, "That's what I remember him saying." The written agreement creates evidence of the bargain the parties actually made. Now imagine the disagreement is $5,000 instead of a refrigerator. During the inspection, the HVAC contractor tells Marcus and Elena that the air conditioning system is nearing the end of its expected useful life. David does not want to replace it. Standing in the kitchen, he tells Marcus, "I'll give you $5,000 toward it." Marcus accepts, everyone shakes hands, and the agents leave believing the problem is resolved. Several days later, Marcus asks Daniel where the $5,000 credit appears in the transaction paperwork. Daniel realizes it was never properly documented. Ashley calls David, who responds, "I didn't promise them $5,000. I said I would see what I could do." Here's where many agents get into trouble. They become witnesses to competing versions of a conversation, instead of making sure the agreement was properly documented when it occurred. Arizona courts have addressed modifications to agreements subject to the statute of frauds. In Best v. Edwards, the Arizona Court of Appeals explained that when an agreement required to satisfy the statute of frauds is materially modified, the modification may itself need to satisfy the statute of frauds. For the Arizona licensee, the practical lesson is far more important than memorizing the case name. When the parties agree to a material contractual change, properly document that change. That could involve a change in price, closing date, seller concession, property included in the transaction, or another material obligation. Don't assume that because the original contract is written, every later verbal change is automatically enforceable. But I have the text message. Now let's bring the transaction into the modern world. David texts Ashley, "Fine, tell them I'll do the $5,000 credit." Ashley forwards the message to Daniel. Marcus says, "Perfect, we have it in writing now." Slow down. Arizona recognizes electronic records and electronic signatures under its electronic transactions laws, including ARS Section 44-7007. Electronic contracting is part of everyday real estate practice. However, that does not mean an Arizona licensee should make a legal determination that every text message, email, typed name, emoji, or "sounds good" response automatically modifies an existing purchase contract. If the parties have agreed to change their contractual obligations, properly document the agreement using the appropriate transaction document and obtain the required signatures. If the parties later disagree about whether an electronic communication created an enforceable agreement, that's no longer an argument the real estate agent should try to decide. Get the designated broker involved and recommend legal counsel when appropriate. This is why experienced brokers tell their agents that the transaction file should tell the story. Another broker, an ADRE investigator, an attorney, or a court reviewing the file later should not have to search through dozens of text messages trying to figure out what happened. Then David makes a different phone call. The refrigerator issue is resolved, the HVAC agreement is properly documented, and everyone moves forward. Then, late Friday afternoon, Ashley receives another call from David. This time, he isn't calling about the house. David tells her that his business has slowed dramatically. He has been moving money around trying to keep everything current, but he finally admits something he has not told Ashley before. He missed his last mortgage payment, and another payment is approaching. Ashley looks at the purchase contract on her computer. What began as an ordinary Arizona resale may be moving toward financial distress. That written contract is about to become much more important. Before we follow David any further toward a possible short sale or foreclosure, however, there is another piece of contract law we need to understand. Agents regularly hear words such as valid, void, voidable, and unenforceable, but those words do not mean the same thing. Understanding the difference is where our story goes next. Online discussion 1. David verbally tells Marcus during the inspection that he will provide a $5,000 HVAC credit, but nobody documents the agreement. What should the agents have done? Answer. Once the parties actually agreed to a material contractual change, the agents should have properly documented the agreement, using the appropriate transaction document, and obtained the necessary signatures. Relying on a verbal conversation creates unnecessary uncertainty about what was promised. Proper documentation helps establish the parties' agreement and protects the transaction from later misunderstandings. Question 2. Why does Arizona's statute of frauds matter to a real estate licensee, even though the licensee is not an attorney? Answer. Arizona licensees routinely facilitate transactions involving interest in real property, so they need to understand the importance of written agreements and proper documentation. This knowledge helps agents manage transactions and prevent avoidable disputes. It does not authorize an agent to give legal opinions about enforceability. When the parties dispute whether an agreement is legally enforceable, the designated broker and appropriate legal counsel should become involved. 3. David sends a text agreeing to a $5,000 credit. Why shouldn't Ashley simply tell everyone that the contract has definitely been legally amended? Answer. Electronic communications can have legal significance, but whether a particular communication satisfies all requirements for an enforceable contractual modification can depend on the circumstances. Ashley should focus on properly documenting the parties' agreement, rather than making a legal determination. If enforceability is disputed, she should involve her designated broker and recommend legal counsel as appropriate.